Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In the previous lecture, we examined employee confidentiality agreements, how to draft them, what makes them enforceable, and why so many fail in litigation. We learned that contracts are foundational, but they're not self-executing. They need to be embedded in operational systems that actually work. Now, in this second lecture of Module 4, we turn to those operational systems. Specifically, we're going to explore what I call the joiner mover lever protocol, the framework for managing trade secret risk at the three highest vulnerability moments in the employee lifecycle. Joiners are new employees or contractors coming into the organization. They need access to do their jobs, but they also bring risks from previous employment, and they need clear expectations about confidentiality from day one. Movers are existing employees transitioning internally, changing roles, getting promoted, shifting teams. These transitions are often forgotten in trade secret planning, but they create significant exposure when access rights aren't updated and obligations aren't reinforced. Leavers are employees departing the organization, whether for competitors, new industries, retirement, or termination. This is the moment of maximum vulnerability, when knowledge walks out the door and files get downloaded. Each of these moments demands a specific documented protocol. Courts evaluating whether a company took reasonable efforts to protect its secrets look closely at what happened during these transitions. Did the company restrict access? Did it remind employees of their obligations? Did it document the process? Or did it treat these moments casually, assuming that signing an NDA at onboarding was enough? By the end of this lecture, you'll understand that trade secret protection isn't a static state. It's an active process that must adapt to the employee life cycle. And you'll have a concrete framework for designing protocols that actually work. Let's start with joiners. The first day of employment is not just an administrative formality. It's a legal and operational checkpoint. What happens on day one, and in the weeks that follow, sets the tone for how seriously the company treats confidentiality. Courts expect companies to use onboarding as an opportunity to establish clear expectations, document obligations, and provide training that goes beyond a stack of forms. When trade secret litigation arises, judges will ask, did the company tell this employee what information was confidential? Did it explain how to handle sensitive materials? Did it make clear that confidentiality obligations would continue even after employment ended? If the answer is no, or if the only evidence is a signature on a generic NDA buried in an onboarding packet, the company's case is already weakened. Pre-employment diligence is the first step. Before a new hire starts, the company should conduct background checks appropriate to the sensitivity of the role. For positions involving access to high-value trade secrets, this might include verifying employment history, checking for non-compete obligations with prior employers, and requiring a clean hands representation, a statement that the employee is not bringing confidential information from previous jobs and will not use or disclose such information while employed. This isn't just about protecting your secrets. It's about avoiding liability for misappropriating someone else's. If a new hire brings proprietary information from a former employer and uses it in your organization, you could face litigation even if you had no knowledge of the breach. Courts have held that companies have a duty to inquire, especially when hiring from direct competitors, or when the employee's new role closely mirrors their prior position. Day one documentation comes next. The new employee should sign all relevant agreements, NDA, invention assignment clause, and any applicable non-compete or non-solicitation provisions before accessing any confidential information. Timing matters. Courts have questioned the validity of agreements signed after the employee already gained access, because consideration becomes ambiguous and the prospective nature of the obligation is lost. But signing documents isn't enough. The company must also explain what those documents mean. This is where onboarding training becomes critical. Employees should receive clear, role-specific guidance on what qualifies as a trade secret in the context of their work. A software engineer needs to know that source code, architecture diagrams, and internal algorithms are protected. A salesperson needs to know that customer lists, pricing models, and strategic account plans are confidential. A manufacturing technician needs to know that process specifications, formulas, and equipment configurations are trade secrets. Generic training, don't share confidential information, is insufficient. Courts look for evidence that the company made confidentiality concrete, not abstract. The best training uses real examples from the employee's actual responsibilities. It walks through how to store documents, where to save work, what systems require credentials, and how to escalate questions or report concerns. Access provisioning should be limited and documented. On day one, the new employee should receive only the access necessary to perform their immediate duties. Not every engineer needs access to every code base. Not every marketer needs visibility into financial projections. Overly broad access creates unnecessary risk, and courts may view it as evidence that the company didn't take need-to-know principles seriously. Access should be tied to role, documented in system logs, and reviewed periodically. If an employee later moves to a different team or leaves the company, those logs become critical evidence of what they could have seen and when. Finally, acknowledgement and documentation close the loop. After onboarding training, the employee should sign an acknowledgement form confirming that they've reviewed the policies, understand their confidentiality obligations, and know how to handle trade secrets. This document isn't just for HR files, it's evidence. If litigation arises, the company will need to prove that the employee was informed. A signed acknowledgement, combined with training records and access logs, creates a defensible timeline. Let me give you an example of why this matters. In United States versus Jin, a Motorola engineer was convicted under the Economic Espionage Act for stealing thousands of proprietary documents before an unannounced trip to China. Motorola's case succeeded in part because the company could show exactly what Jin had access to, when she accessed it, and how her behavior deviated from normal patterns. The system logs revealed abnormal download activity in the weeks before her departure, and those logs existed because Motorola had implemented robust access controls and monitoring from the moment employees joined. If Motorola hadn't documented Jin's access at onboarding, hadn't restricted it to her actual role, and hadn't monitored it over time, the case would have been far weaker. The joiner protocol created the foundation for enforcement. Joiners and leavers get attention in trade secret planning. But there's a third category that's often overlooked. Movers, employees who transition internally. Promotions, lateral moves, project reassignments, team reorganizations. These are routine business events, but each one creates trade secret vulnerability. Why? Because internal transitions often involve changes in access without corresponding changes in controls or documentation. An employee who moves from marketing to product development might retain access to customer data they no longer need. A manager promoted to a new division might keep credentials for systems outside their new responsibilities. A contractor switching projects might still have files from earlier work sitting on their laptop. Courts evaluating reasonable efforts look for evidence that companies managed access dynamically, not just at hiring and departure, but throughout employment. When access rights are never updated, when old permissions accumulate, and when employees can see information far beyond their current role, judges may conclude that the company didn't truly implement need-to-know restrictions. Role change reviews are the core of mover protocols. Whenever an employee changes positions, the company should conduct a formal review of their access rights. What systems do they currently have access to? What should they have access to in their new role? What permissions should be revoked? This review should be documented and executed promptly, ideally before the transition takes effect. For promotions, the company should also update confidentiality obligations if the new role involves access to more sensitive information. Some companies require employees to sign updated non-disclosure agreements when they're promoted to executive positions or gain access to strategic planning materials. Others use role-specific addenda that clarify what new categories of information are now covered by their confidentiality obligations. Retraining is often appropriate during internal transitions. An employee moving from engineering to sales needs different guidance on trade secret handling. They'll be working with customer-facing materials, pricing information, and market strategies, not technical specifications and source code. A brief training session that explains what's confidential in their new context reinforces the company's culture of secrecy and documents that the employee understood their updated responsibilities. Exit from prior roles also matters. When an employee leaves one team for another, the old team should be notified. Shared drives should be updated. Group email lists should be revised. Project-specific materials that the employee accessed in their prior role should be collected or archived if they're not needed in the new position. This prevents the gradual accumulation of access, the silent drift where long-tenured employees end up with visibility into every corner of the organization, simply because permissions were never revoked. Mover protocols also address conflict of interest concerns. Imagine an employee who worked on a confidential partnership with Company A, then transferred to a team negotiating a competing deal with Company B. Without clear boundaries, that employee might inadvertently or intentionally use insights from the first project to inform the second. Courts have found trade secret violations in situations where internal information flow wasn't adequately controlled. The solution isn't to prevent all internal mobility. That would be impractical and counterproductive. The solution is to document transitions, update access, provide targeted training, and create a record showing that the company didn't treat movement casually. One of the simplest but most effective mover protocols is the role transition checklist. Before an employee officially changes roles, their manager and IT should complete a short checklist. Has access been reviewed? Have unnecessary permissions been revoked? Has the employee signed any required updates to confidentiality obligations? Has the new team been briefed on the employee's prior access? Have files from the old role been returned or archived? This checklist doesn't need to be elaborate, but it does need to exist, and it needs to be followed consistently. When litigation arises, courts give significant weight to evidence that the company had structured processes and followed them. The most dangerous moment in the life cycle of a trade secret is when an employee leaves. Departures concentrate vulnerability. They trigger downloads, file transfers, hasty communications, and quiet copying. They disrupt workflows, reassign responsibilities, and create uncertainty about what information will be taken, remembered, or reused. Courts know this. They routinely examine what a company did when a key employee left, and they judge the company's entire trade secret program based on how it responded in that moment. If the company acted quickly, deliberately, and systematically, disabling access, collecting devices, conducting exit interviews, documenting obligations, courts are far more likely to find that reasonable efforts were taken. If the company did nothing until weeks later, after discovering that files were gone, judges will question whether secrecy was ever a real priority. Immediate access revocation is non-negotiable. The moment an employee gives notice, or the moment termination is decided, their access to confidential systems should be restricted. This doesn't mean cutting off all access immediately in every case. For employees working through a notice period, limited access may be necessary to complete handoffs, but access to high-value trade secrets, strategic documents, and proprietary systems should be revoked or closely monitored. Some companies implement a two-tier approach. General access continues during the notice period, but access to crown jewel secrets is removed immediately. Others place departing employees on garden leave, paying them through the notice period but restricting their physical and digital access to the workplace. The specific approach depends on the role, the sensitivity of the information, and the circumstances of departure. But some restriction must occur, and it must be documented. Device collection follows. Company-owned laptops, phones, tablets, external drives, access cards, and any other hardware must be returned before the employee's final day, or on it at the latest. IT should verify that devices have been wiped of personal data and that any company files have been transferred to secure storage. If an employee resists returning a device or claims it's lost, that should trigger an immediate investigation and, if necessary, legal action. Audit of recent activity provides visibility into what the employee accessed in the final weeks of employment. System logs should be reviewed for unusual patterns, large-scale downloads, access to files outside the employee's normal responsibilities, transfers to personal email accounts or cloud storage, connections to external drives, or login activity at odd hours. These patterns don't prove misappropriation on their own, but they provide the evidentiary foundation for investigation and, if necessary, litigation. In United States versus Gin, Motorola's monitoring systems flagged abnormal download activity by an engineer in the weeks before her unannounced departure. That early detection allowed the company to investigate, confirm the breach, and involve law enforcement before Jin boarded a flight to China with thousands of proprietary documents. The case succeeded because Motorola's lever protocol included real-time monitoring and immediate response. Exit interviews are where legal obligations are restated and documented. Even if the employee signed an NDA years ago, the company strengthens its position by revisiting those obligations at departure. The exit interview should cover several key points. Reminder of continuing confidentiality obligations, including post-employment duties under the NDA. Confirmation that the employee has returned all company property, documents, and files. Explanation that trade secrets remain protected even after employment ends. Clarification that the employee may not use, disclose, or rely on confidential information at their next job. Opportunity for the employee to ask questions or report any concerns. This conversation should be documented. Some companies use a separation agreement or exit certification form that the employee signs, confirming their understanding and compliance. Others send a follow-up email summarizing the discussion and requesting written confirmation. Either way, the goal is to create a contemporaneous record that the company reminded the employee clearly and specifically of their ongoing duties. Post-departure monitoring continues the process. If the employee is joining a competitor, the company may choose to send a letter to the new employer outlining the departing employee's confidentiality obligations and requesting assurance that trade secrets will not be accessed or used. These letters are not threats, they're preventive notices. Courts have cited them as evidence that the company acted proactively to preserve secrecy. Some companies also monitor publicly available information, LinkedIn updates, patent filings, product announcements, for signs that former employees may be using confidential information in their new roles. This isn't espionage, it's due diligence. If red flags appear, the company can investigate further and take legal action if warranted. Finally, internal adjustments complete the lever protocol. The departing employee's team should be reminded not to forward documents or communicate about confidential projects with the former colleague. Shared access to files should be revoked. Clients or partners should be notified if necessary. And the company should update its trade secret inventory to reflect any information the departing employee had access to. Because if misappropriation is later suspected, that inventory will help define what was at risk. Let me close with a litigation perspective. When trade secret cases go to trial, one of the first battles is over whether the plaintiff adequately protected its secrets. The defendant will argue, if this information was really so important, why didn't the company restrict access? Why didn't it train employees? Why didn't it do anything when I left? The joiner-mover-lever protocol is how you answer those questions. It's how you show the court that secrecy wasn't just a legal claim asserted after the fact. It was an operational reality, embedded in your systems, enforced at every transition, and documented at every step. In Bimbo Bakeries USA versus Botticella, a Third Circuit case from 2010, the plaintiff successfully obtained an injunction preventing a departing executive from joining a competitor, even before any actual misappropriation occurred. Why? Because Bimbo could show that the executive had continued accessing confidential files during his final weeks, that he had been evasive during exit discussions, and that the company had clear, documented protocols for what should have happened. The protocol wasn't just followed, it created the evidentiary record that made the injunction possible. Contrast that with cases where companies had no protocols, no exit interviews, no device collection, no access logs. In those cases, even clear wrongdoing, files taken, secrets disclosed, often fails because the plaintiff can't prove what the defendant had access to when they obtained it, or whether the company ever treated it as confidential. The joiner-mover-lever protocol doesn't guarantee you'll win, but it dramatically improves your odds. It turns a reactive scramble into a disciplined response. It converts anecdotes into evidence, and it shows the court that you took reasonable efforts, not just on paper, but in practice. Let's recap. The joiner-mover-lever protocol is the operational backbone of internal trade secret protection. It recognizes that employee transitions are the highest risk moments, and it builds structured processes to manage those moments. Joiners need clear expectations from day one, enforceable agreements, role-specific training, limited access, and documented acknowledgement. Pre-employment diligence and clean hands representations protect against inbound risks. Movers need updated access, refreshed training, and formal role change reviews. Internal transitions are often overlooked, but they create significant exposure when permissions accumulate and obligations aren't reinforced. Leavers need immediate access restrictions, device collection, activity audits, exit interviews, and post-departure monitoring. This is the moment of maximum vulnerability and the moment courts scrutinize most closely. In our next lecture, we'll turn to training, culture, and enforcement, the ongoing systems that make trade secret protection real. We'll explore how to educate employees, build a culture of confidentiality, and enforce policies consistently. Because even the best protocols fail if people don't understand them or if the company tolerates violations. Thanks for listening. See you in the next lecture.